Good afternoon. This lecture is on sources of Muslim law. Muslim law in India means that portion of Islamic civil law which is applied to Muslims as a personal law. It consists of the injunctions of Quran, of the traditions introduced by the practice of the Prophet, of the common opinion of the Juris, and of the analogical deductions of the Qiyas. Muslim means one who believes in Islam, and Islam means submission to the will of God. A person born as a Muslim continues to be a Muslim until he renounces Islam after attaining majority. Any person who professes the Mohammedan religion is a Muslim. He acknowledges that there is only one God, that is Allah, and that the Prophet Muhammad is the messenger of, and that Muhammad is the prophet or the messenger of God. Sources of law signifies original materials where the contents of that law are to be found and are made available for people at large. Sources of Muslim law may be broadly categorized into primary sources and the secondary sources. Under the primary sources we have Quran, Sunnahs or Ahadith or the traditions of the Prophet Muhammad, the Ijmas and the Qiyas. We shall take up the first one, the Quran. What is Quran? Quran is the first source of Muslim law in point of time as well as in importance. It is a revelation of Allah through the angel Gabriel to the Prophet Muhammad when he was meditating in the cave during Ramzan. Quran regulates individual social, secular and spiritual life of Muslims. It contains very words of God. The Quran has been divided into 114 chapters and 6,237 verses. It is also called ayats. Now that Quran comes from the God or the very words of God, it is the primary sources and it is unchangeable. And Quran deals with a variety of subjects and a very small part of it comes into the domain of law. Basically, it is an admixture of religion, law and morality. It deals with the institutions of public prayer, fasting, pilgrimage, prohibition of wine, and also deals with marriage, divorce and inheritance. Quran came into being when the people were less in number. Quran catered only to the limited needs of a Muslim. It was silent regarding quite a few aspects, because of which there was a need for another source of Muslim law, which came in the form of Sunnahs or Hadiths or the traditions of the Prophet Muhammad. Whenever a new dispute came into being or whenever there was a new ambiguity which Quran could not answer, the Prophet Muhammad used to apply his mind and used to give his opinion based on his own logic, and at times he used to remain silent. So in these circumstances, both the words uttered by the Prophet Muhammad and also silence came to be called as the traditions of the Prophet Muhammad or Sunnahs or Hadiths. These Sunnahs these Sunnahs were whatever the Prophet said or did without reference to God is treated as his traditions and considered to be the second source of Muslim law. Where the words of God could not supply an authority for a given rule of law, Prophet's own words and deeds were treated as an authority because it is believed that even his own sayings are derived from God. Types of Sunnahs. The Sunnah means the Sunnahs were basically given by the Prophet. After his death, Sunnahs were given by the companions of the Prophet. After the death of the companions of the Prophet, Their successors, that is, the successors of the companions, started telling us the Sunnahs. After the death of the successors of the companions, their progeny, that is, their children or their successors, were the source of Sunnahs. And after the death of this generation, also the successors of the successors of the successors of the companions started giving out the Sunnahs. Due to all this, it led to a lot of confusion. Nothing was reduced to writing. Everything was in the vacuum, because of which it led to a lot of commotion, ambiguities, confusions galore, and this gave room for another source of Muslim law called the ijmas. Ijmas are again can be divided into ijma of Juris, ijma of the companions of the Prophet, ijma of the people. We shall take up the first one, the ijma of the Juris. Whenever the Juris came together and gave their opinion, general opinion, this became ijma of the Juris. And who could be a jurist? Jurist is one who was a Muslim, who had a thorough knowledge of Quran. And next is ijma of the companions of the Prophet, that is, those who saw the Prophet or the jurists who saw the Prophet deciding a particular matter in a particular manner. They started giving the ijmas. And the last one is the ijma of the people, that is, this kind of ijma, of course, though not does not have much of importance, it is also one of the primary sources of Islam. That is, whatever people thought was right and whatever people thought that Prophet Muhammad would approve, that became the ijmas. Ijmas also suffered from the drawbacks, because of which another source of Muslim law came into being, that is called qiyas, or the analogical deductions. These qiyas play the same role as that of judicial precedents in modern world. That is, whenever a new dispute or an ambiguity came up, they would compare this ambiguity with the already decided cases. That is, they would revert back to the already decided disputes or the cases or a rule of law. And if the similar pattern of facts are repeated, they would refer the already decided matter and they would give the decision on the same lines. That is, in the modern world, we call it as a judicial precedent, but in those days, it was called analogical deduction, or which is also called qiyas. The opinions of the judges and scholars were called fatwas, and fatwa also became the primary source of Muslim law. Qiyas means reasoning by analogy, and of course, qiyas do not purport to create new law, but merely to apply old established principles to new circumstances. While solving problems through qiyas, it has to be considered that such things shall not be adverse to the basics of Quran, Sunnah, and Ijma. Next lecture would be on the next piece of lecture would be on the modern source of Muslim law.